Oh my. I'm not even paying attention. Ladies and gentlemen, guitar's whining, keyboard's crying, and all that stuff, and somebody in Harris County, Texas has the blues. I'm about to run out of time for the intro because I'm chatting with everybody in the chat already, and I'm not paying attention to what I'm supposed to be doing, which is hosting the Fleischer Forum right now at 9 p.m. tonight. Ladies and gentlemen, it's good to see you here. I'm your lone wolf Usul. We're about to get started. Show's gonna roll. Let's roll, nerds. Good to see all of you. Love you. You know that. You all know that, right? Important, you know that. Good. Want to make sure. Here we go. Let's roll. Roll out.
Okay, you ready? Let's roll. Let's roll, nerds.
All right, Judge, page 2, Bonito, Stephen, come on up. Oh, it was released from jail.
You're Stephen Bonito. Mr. Bonito, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On 4/29/2024 in Harris County, Texas, officers observed a vehicle run a red light and they attempted a traffic stop. The vehicle evaded for 0.59 miles, speeding 63 miles per hour in a 30-mile-per-hour zone before crashing into a tree. The driver detained the defendant got detained and was sent to Woodland Memorial Hermann Hospital for his injuries. Officers recovered a bag from the vehicle containing a firearm. So he ran a red light, they attempted a traffic stop, he evaded for 0.59 miles, and then they found a firearm on him.
Where was it? Don't say anything, please.
He was traveling southbound in the 29800 block.
No. I mean, like, where was the gun? I guess, yeah. No, it's a company of felony. Mr. Benito, I'm going to find that the probable cause is I'm going to find probable cause to go forward with the case. How old are you, sir?
He was inside the center console.
17. What do you do for a living, sir?
We're not worried.
Are you in high school?
Online school. Online school?
What does that mean?
Yeah, I'm enrolled in online school.
Okay, I'm sending you for a drug test. And I don't want you to smoke weed. I don't want you to use the alcohol. I don't want you to have any weapons. Do you understand? Do you have a Texas driver license? You're not allowed to drive. You will be signing a promise with me today, Mr. Benito. I want you to understand that I take it extremely serious. You are only 17 and you're starting your life out now. You have an open third-degree felony. You're looking at up to 10 years in prison. This is not a good way to start life, man. Really. You have your whole life ahead of you, and I'm going to tell you, you end up in prison, it's a veritable nightmare. We're going to do everything in our power to make sure that you go on the up and up. I want you to stay in school. That's also a condition of your bond. Do you understand? I don't want you out in the middle of the night. I'm giving you a curfew as well. I'll give you a lawyer today, but we're going to work hard and fast to make sure that you go on the up and up. You understand? No more weapons and no driving. Who are you here with today? How'd you get here? Okay, don't drive. I'm not asking much.
It was in the center console. I just need to review the report.
Okay. This is an affidavit. This is a promise that you're going to make to me. And if I find that you drive, and I'm telling you, I don't care what your reason is, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you drive. The problem with driving without insurance, Mr. Bonito, is that if you get into an accident, and let's say you kill someone in that accident, who do you think they're going to come after? Right. No, not after you. They're going to come after the deep pockets, which are probably mom and pop. You don't want that to happen. You understand? Come on. So let's send him for a drug test. We'll have him come back, appoint a lawyer now, and then we'll, get with the lawyer to see how we go forward with.
Page 17, Jones.
Happy with you, Mr. Jones. You've now picked up a third case. You now stand charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 5th, 2024, officer initiated a traffic stop on defendant's vehicle for failure to display a front license plate while he was driving in the 5900 block of Mercer Street in Harris County, Texas. Officer made contact with the occupants and detected an odor of marijuana emitting from the driver's side window. All 3 occupants were detained for a PC search. The defendant provided the name of Kendrick Johnson with a date of birth of 8/30/2006, which returned with nothing. Officer used a mobile AFIS device and found defendant's real name to be Demarcus Jones with the date of birth of 8/30/06.
I ordered you as a condition of your bond, and you promised me when you got here last time that you would not drive. Stop. Did you say that he was a driver here? Stop. Don't say anything. I don't want you, don't. You have the right to remain silent. Exercise that right. I was under the impression, Rosette, that he's driving here, is he not?
There were 3 occupants in the car, Judge. I'm trying to see if they clarified.
We're not going to wait for that case to end, ladies and gentlemen. There's been a Colin raid. We are now in the midst of the obligatory Colin pause. Ladies and gentlemen, I want to thank all the Cooligans, all the Biggin Raiders, everybody who has rolled in from all of the great sources tonight to the Fleischer Forum. We're happy to have you. This is the obligatory Colin pause for the raid, and now the obligatory Colin pause is over. Enjoy the rest of the show.
He was a passenger. He was the front passenger, Judge.
Okay, so tell me, let's do a deeper dive.
Sorry?
Let's do a deeper dive. So they pull him over. He's the passenger.
There was an odor of marijuana detected.
So what happened next?
So they detained all 3 occupants for
Okay.
a probable cause search.
All
The
right.
driver was identified by his driver's license, and the front seat passenger, which is the defendant, provided the name of Kendrick Johnson. And a mobile AFIS revealed that wasn't his true name. And so he was charged with failure to ID.
Do we have any co-defendants in this case?
Yes, John Burns.
Okay. So what's the cause number on that?
On that one?
Yeah.
It's 25-417-01. That's in court 15.
Okay, is there a third co-defendant as well? Okay. Mr. Jones, I'm glad that you're not driving. Regardless, you've picked up a new case. I don't know what we're going to do, but normally when you pick up a new case while you're on bond, we revoke the bond on the old case. So, I mean, it goes with you. I'm going to appoint your lawyer today. We'll figure out how we go forward. But for now, I'm going to take you in. I'm going to appoint your lawyer. We'll see how we go forward. But you're supposed to behave yourself while you're on bond. You've now picked up a third case. You first have a felony theft. You got a second case, and now you've picked up a third case. It goes with you. Can you please one number one?
All right, Judge, next is page 29. Villegas, Kamala.
So, hey, we're gonna monitor him now. No contact with any of the co-defendants. No alcohol, no dope. And I'm gonna appoint him a lawyer. I don't know what we're gonna do, whether we keep or not, but if for some reason we don't, I'm gonna send him for a test because I want to know what if anything. Did you say there was another one?
Villegas, to bring them out. That's
Was that the last one?
Sorry, what's that? Judge.
Jeffrey Villegas? Am I right? Okay.
Mr. Villegas, Your Honor.
Got it. Okay, so, all right, good morning, Mr. Villegas. So the reason that we're taking you in now is because you have a no bond warrant on an aggravated assault with a deadly weapon. I see that you're on bond for an aggravated assault from January. I guess there was a simultaneous also, I'm sorry. You an aggravated assault of a family member. You have a second aggravated assault. This one was a deadly weapon. And now with us, you picked up an unlawful restraint and an assault of a family member. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. All we're going to do is probable cause in these two. I'm going to keep you. It looks like you have a lawyer. I don't want to do anything until we get your lawyer. Okay, so give me a second. Let me see. I have Mr. Villegas here. Are you going to be in today? You want me to just wait then to do probable cause? Sure. Okay. All right. Bye. Do you mind just putting back and we'll do it here momentarily? Thanks. Okay. I'm going to hold until, okay. Hi, good morning. How are you? Thanks for being patient.
Mr. Sali, they're filing the dismissal on this case right now.
Okay, I'll sign it. Let me see if it's here. You too, take care. I'm signing it now, Dan, if you want a copy.
Yes, sir.
Yeah. Okay,
Thank you.
hi, of course. Sorry, they've been waiting, Joel. It's okay.
Shanika Smith is on docket, Judge.
Yes, sir.
Ready to get the final pretrial.
Okay,
So we're just waiting. You to give us
you've turned everything in?
everything's turned in.
Do we know? Oh, when did you turn in? Yesterday?
Day before you.
Okay. Is your client here?
She's right there in the red cup, Judge.
Has she done it to you guys yet?
You know, I don't know.
Since she's here now, do you want to go ahead and do it?
You signed up for it?
Yeah, we can send her to do a walkthrough now because that's something she has to do regardless. An hour? An hour?
Can she come back and do it today? Okay, perfect.
Yeah, if she needs to go now, yeah, we can schedule it for later, but since she's here, why go and come back?
Okay.
You know, it's up to her if she wants to do it, since she's already here now.
Chief of Staff and County Attorney for VN. I know she had meetings, that's all.
Oh, okay. It's up to her, however she wants to do it. You guys dictate, you tell me what you want to do,
Okay.
but I'm okay with however. Yeah, okay.
And that's the now.
Yes, sir. Thank you. Great to
Thank
see
you.
you
We do
like
have another
always.
pending matter though, Judge, that's on docket today, Jesse Herrera Jr.
Page 11.
Yeah, okay.
For this one, Judge, just wanted to give the court an update because I know we're at the 6-month mark now. He would qualify for entry into the DWI PTI program as well, but I know because there's an accident involved in this one, I know 8A Beetle is going to require that accident report. State has been diligently trying to seek that from HPD. It looks like we finally got an answer this morning that it was finally sent to the state so that they can then check to get it to us so that I can then submit that to 8A Beetle along with the
Okay.
mitigation packet to get an answer from him.
How long do you want?
I guess it's gonna be on the state to know how
Yeah, so
quick we can get the accident?
the officer told me that she uploaded it into the system, and so our admin just has to re-request
How
it.
on earth are you gonna take 6 months to upload a freaking report?
don't know,
I mean,
Judge.
really?
I called her on the 22nd of last month and asked her about it, and she said she would do it, and then no.
Unacceptable. So you still don't have it, right? Is that what you're telling me?
Our admin still has to
So
request
this
it
is what
from
we're
their
doing.
system.
Subpoenaing her to court. You know, she's got a week to be here. If she's not here in a week with report in hand, I'm gonna have a show cause hearing. And that's it. But it's unacceptable that we're at 172 days and something that's as easy as just hitting a freaking button, you can't do it. Unacceptable. So we're gonna subpoena her to come to court. Let's set it 1 week. She must appear with report in hand. Otherwise, I'm gonna have a contempt hearing. That's
Judge,
it.
are you gonna require his parents, it was waived, I can have him here
No.
next week
Oh.
if it's required, Judge.
So do this, start working on the mitigation packet if you haven't already. He's gonna have to do a TRAS, so can you have everything done, do you think, by that time, so we can ready submit it and do the TRAS, you think?
I will say at this moment, yes, I can get him to have everything done within this week.
If
I'll have
not,
him work on it.
I get it, but if you need more time after that, just tell me and we'll work
Yes.
with you.
And there is another pending with that, and I did speak with the state, and I spoke with pretrial as well. He is scheduled to do the random calling in every day for drug tests. He's had no issues with it, no positive drug tests. I'm at this time requesting an amendment to the bond conditions to remove that condition, Judge.
Has he had any test? He's never had a test. Let me send him for a test now. If he's negative, then yeah.
Okay.
Okay.
Do you want me to, he's not here, so is he gonna
Oh.
just need to call pretrial or call in, or how's that gonna work, Judge? How do you want me to? Okay, so then I will check with pretrial, get that scheduled. Okay, perfect.
Okay.
Thank you, Judge.
Judge, how much time on both? So 1 week on this one and Smith,
What did we say on Smith?
walk through T-Res?
Oh, he's doing the TRAS today, so 2 weeks, 2.5 weeks?
Oh, the T-Res is gonna be done on the 18th, so not.
Oh, okay, so I guess 3 weeks. Okay, Julie. Yes, ma'am. Good morning.
Good. I put a motion to sub in your queue. It's on Caesar Jerome.
Is it on for today's topic? Okay,
He said on the 23rd. We just got his felony reset to January 24th.
so he's currently in custody, right?
Yes.
Do you anticipate him bonding out?
No.
If he does, he's got to be here the next day so we can do conditions.
Yeah, Judge.
But it looks like the case is not set for January 24th. Do you want the day after?
Yeah, that's perfect. Okay, thank you.
Good morning. Ready?
Yes, sir. I'm here at Louis Spoon Hall. Yes, sir. We talked, he's a low BAC, but he did get into an accident. So we had to do a mitigation.
It's not old though.
Okay,
I mean, it's
cool.
getting up there. It's 130 days, so you got another 50 until we start beating, you know?
Yeah, it's just, we were trying to get everything in early because there's rumors that PTI might go away.
Go away?
Yeah.
No. Really?
Or just be more restrictive. I hope
I
it's
think
more
that,
restrictive.
no, I think that, I don't know for sure, but, because, I mean,
You're not saying
I'd be
anything.
surprised if it were to completely go away.
Right.
I'd be
would-
very, very
But I think,
surprised, you know?
like really high BACs, that type of stuff. Or like if you had some felony stuff or something.
What's the BAC here?
Oh, no,
it's
he's a
like-
0.08,
yeah,
yeah.
it's-
I just had him
Yeah.
at 2.28, that's what I mean. Yeah. All right,
Yeah, okay, Herman,
thanks, yeah.
for sure.
Yeah, we're supposed to-
Yeah, if you need more time, you got it.
Last said Ms. Smith wasn't here, you told me the resolution is here. She has been on pretrial, she's had no violations. And
Has she ever tested? Yeah, she's never even tested.
and a violation then, okay.
It's crazy. It's like some people get called in 15 times and then some people never get called in once. And I don't understand what,
I take that back, but I didn't know she hadn't been called. She said, do I need to keep calling in, but she's never been.
if we test her and she's negative, then we'll take her on.
Okay.
So she's here now, right? Do you want to send her for one now? Oh, or she got to go, I guess, right? It's up to you. You tell me. If she tests and she's negative, I'll take her on because it's already been 170 days.
Thank you. May I
For
be-
sure. Yes, sir.
Hey, Judge, how are you?
Chad, always a pleasure. You ready?
Yes, ready.
Come on. So, Villegas,
Yes.
looks like he's made quite a bit of high bonds. So we're not holding him. He's got bonds in our court.
Okay.
We'll leave as is. But I don't know anything that's happened. So let's do it real quick and then we'll figure out how. He's just being held on that no bond upstairs on the ag assault. So you're familiar with that one, right?
Yes.
Yeah, okay. All right, so Mr. Vegas, we have your lawyer here. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Like I've already told you, you're charged with assault. You're also charged with unlawful restraint. Both of those, you're facing up to a year in jail and or a $4,000 fine. Okay.
The complainant and the defendant are in a dating relationship. On December 5th, 2024, officers were dispatched to a family violence call. Officer met with the complainant who stated the defendant followed her down from their apartment to her vehicle and had stiff-armed her face. Complainant then left and went to a friend's apartment and the defendant.
Did you say he stiff-armed her face?
Yes, Judge.
Okay.
Complainant then left and went to a friend's apartment and the defendant followed. The defendant told the complainant to get into his car because he wouldn't talk to her through the window. The complainant got into the passenger side seat and the defendant reversed aggressively and began driving south on North Main. The complainant stated she tried to exit the vehicle when the defendant stopped at an intersection, but the defendant grabbed her arm and prevented her from leaving. The defendant then began driving west on Rolling Brook Drive. The defendant stopped at another intersection and the complainant was able to exit the vehicle. She began running away from the vehicle and the defendant ran up behind her, grabbed her by the hair and slammed her face into the brick wall of the subway. The defendant then dragged the complainant by her hair to the truck, dragging her to the ground. The defendant tried to put the complainant in the truck, but the complainant was able to run away. Witness by an unknown vehicle tried to help, and the defendant was ID'd by his Texas driver's license.
Mr. Villegas, I'm going to find that there's probable cause to go forward on both of your cases. A protective order has been issued in this case on the 7th of this month. I would suggest you get to know it. If you violate the protective order, the state can and probably will file a violation of protective order against you. And I'm telling you, it's the capital murder of misdemeanors. It's one of the worst ones that you can pick up. The only thing that we're asking you to do is don't have contact with this person and don't be in possession of any weapons. That's all. As long as you can do that, everything here will be fine. Do you understand? This is going to survive for the length of the case. Don't have any contact. Don't use anyone else to try to have any contact with her. Social media, friends, family, anything like this. Do you understand? So Jed, it looks like the felony case is set for February.
Mm-hmm.
Do you want to, we usually do 30-day settings just so people don't get forgotten about.
Sure.
Are you okay with that?
Yeah, of course.
And then just keep us in the loop, whatever happens, and we'll just keep it, in conjunction with however it goes.
Yes, sir.
Do you have any questions?
We'll talk.
If at some point you bond out, you have to come back here for bond conditions. Okay, I don't know if you're going to bond out, but if you do at some point, you will need bond conditions because I want to ensure that you're not going to have any contact with this person. Okay, for now, we'll just put you back. Yeah, I mean, there's no need for you to say anything at this point. Just, I want you to understand that right. He'll take care of you, Mr. Vegas. We need him just to sign bond conditions saying that he's not going to have any contact, not be in possession of any weapons, and then that's it.
Sure.
Okay?
Sure.
All right.
All right, thank you, Judge.
Fine.
I'll be right back.
I approach your honor.
Of course. Hi.
Judge.
I have a couple cases on your docket, mostly Sarah Flores. She's present for today. We filed a mitigation packet.
What was the last name?
Flores.
Page 6.
Sarah. We filed a mitigation package with Venable.
Okay.
Have not heard back on it yet.
What, you said you filed it when?
Last night.
It's okay, man. It's really, at least he got it done. Is she here now?
She is here.
Let's send her for a T-Rex, right? She's here now. There's no, might as well.
Sure.
And then we'll set you off, 2.5 weeks, 3 weeks to get the response and then do all the other stuff.
He responds usually pretty quickly. He might be penalizing me for business filing on the 9th hour.
No, whatever. No, I don't. Okay, we might as well send her now though, so that we kill two birds with one stone. And then
Normally, I think the only thing that's gonna be an issue is he might require her to do an essay because it was a high VAC.
Okay.
0.199.
Okay. Can we send her now?
Sure.
Okay, and then whatever date you want. Yeah, okay, thanks.
Thank you, guys.
I also,
All right, the first one is page 27. Trevor Ms, come on up.
Do you know if Nathan's coming here today? Up here, sir. Nathan has a case here today? Okay.
What's a fugitive, I guess?
What was it? What page? Got it. You were Mr. Trevor Ms? Shh. Mr. Trevor Ms, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. Oh, guys, crap. I'm sorry. Sorry, John D. And thanks, Mark. This is Mr. Trevor Ms. It's the last name, Trevor Ms. I guess under Trevor.
Sorry about that, Judge.
It's okay.
So officer, are you ready for me?
Yeah, okay. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were dispatched to a bar in Harris County, Texas, in response to a suspicious person. The complaining witness, a security guard, told the officer that the defendant had left the bar and gotten into his car, but then returned a short time later carrying a gun. While there were other parties arguing in the outdoor area of the bar. The defendant took the gun and threw it under the fence. The complaining witness retrieved the gun, took the bullets out, and returned the gun to the defendant and told him to leave. Complaining witness then observed defendant go to the back of the bar and hop the fence to get back inside.
So they had told him to exit the bar, you said?
Yes, Judge.
Okay. Mr. Trevor, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
7.
What do you do with yourself these days? What do you do with yourself these days?
So I'm unemployed, I don't have a job.
How come?
Just moved here. Moved out here.
From where? Okay. What are you planning on doing with yourself?
Job.
Okay. How long has it been since you've had a job?
Like 2-3 years ago.
2-3 years since you've had a job? How do you support it? How do you live? How do you eat? How do you get money? Okay.
Trouble. See my record. I don't be in trouble.
So you have any prior criminal history?
Just carrying a handgun in a motor vehicle that was dismissed.
I'm ordering you as a condition of your bond not to go back to this place. Do you understand? Not to be in possession of weapons. Do you understand? So how are you going to get a lawyer, sir? So you're just going to do nothing and so I don't want to talk to you the case. I don't want to talk about the case, but let me ask you this. You haven't had a job for 2 to 3 years. Why should the people of Harris County have to foot a bill for you when you get to do nothing for 3 years? How is that fair that we all have to pay for your lawyer when you don't do anything? You get to play Xbox all day, just hang out at home and do nothing, and we have to foot the bill for that? How's that fair?
I don't have it. What you want me to do?
So here's what we're gonna do. I'll have you fill out an application. I'm now making a condition of your bond. You got to get a job. And I'm going to bring you back in 2 weeks. I want to see what you've done to get a job. You're 27 years old, dude. This life is really, really tough without money. And the older you get, life doesn't get easier. It gets harder. You get bigger, you get fatter, you get uglier, you lose hair, right? And if you don't have a job, if you don't have a trade, if you don't have a way to make money, what do you think is going to happen? Do you think people are going to keep giving you handouts the rest of your life? That's how we have all these people who walk the street, looking all Quasimodo-like, have no way of getting money, no traits, no skill. That's not the way to go through life, man. Now is when you work your ass so that when you become 60, when you become 70, you have a cushion, you have somewhere to land. So you have a house, you have a nest egg savings. Because if not, I'm going to tell you now, you're going to have a really rotten and miserable life. This life is a journey, and it's really a good journey where you buy nice things, have nice clothes, take nice vacations, pretty wife, kids, or it can be a rotten toilet of an existence where you're in and out of jail. You ain't got no money. You're begging every single person for this and for that. And that's not the way to go through life. Did you even graduate from high school? I want you to get a job. I will give you a lawyer today, but you're not to use alcohol. You're not to use illegal drugs. And I'm going to test you like crazy. I want you to know that now. And I'm going to hold you to a standard as well. Do you understand? And if you don't, life's not going to go well between you and I. I'm just telling you that now. You will be held to a standard. I'm going to bring you back in 2 weeks. And I want to see what you have done to get a job. If you come back here and you ain't got nothing in your hand, it's not going to go well. Do you understand? You might give an application.
Page 28.
You heard the conditions, huh?
No drugs or alcohol.
No, right. Random testing, no alcohol, no dope, no going back to this location, no weapons. And JOB. Okay. Vic,
Venable on page 28.
good morning, Mr. Venable.
Yes, sir.
Mr. Venable, you're charged with 2 counts of assault. One is of a family member. On both of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, Ms.
On January 21st of 2024 in Harris County, Texas, officers were dispatched to an AFM call. Officer met with the complainant. The complainant and the defendant have been dating for 5 months. The complainant and the defendant were arguing. The defendant pushed the complainant to the ground, causing her to scrape her right arm. While the complainant was still on the floor, the defendant stepped on her neck. Officer noted.
Stepped on her neck.
Yes, Judge. Officer noted redness on the complainant's arm and neck.
You know if it impeded breathing?
No, Judge. I don't, I can't, let me check. It wasn't charged as an impeding breath, so.
Well, I know it wasn't charged, but is it?
The DIMS don't say that she had any trouble breathing, but I'll look at the offense report, Judge.
And here's the other thing. The first assault is from October of 23. The second assault is from January of this year. And now we have a felony evading arrest on December 10th.
Yes, Judge.
Were these 2Bs? Was he out on bond for these? Vic, do you know?
It looks like. No,
So
it
this
looks-
is Venable, who's now picked up a 3rd case. He had 2 misdemeanors, one's from 23, one's from 24. Did we ever do PC or had he ever been on bond
No, Judge. It was just a non-arrival.
for the whole time? All right.
Judge, it doesn't say that she had trouble breathing, it just says that it caused her pain.
Okay, can you do probable cause? So that's the family member, right?
That's the AFM,
Okay,
Judge.
can you do the first case? Because I don't think we've done probable cause on that one now.
This is the AFM from January 21st. Oh, the ABI, the one before.
Yeah, the one before.
On 9/29/2023, officers were dispatched. On arrival, officers spoke with the witness, complainant's wife, who said that the defendant assaulted the complainant by slapping him in the face because the complainant's dog killed the defendant's girlfriend's cat. Then officers spoke with the complainant, who said he had invited the defendant into his residence to discuss the situation when the defendant said she should knock the shit out of him. And the next thing complainant knew, the defendant had struck him across the left side of his face with his hand, causing pain.
Mr. Venable, I want you to understand one thing, that I'm going to do everything in my power to protect my community at all costs. And if that means I have to make your bond extremely high, taking you into custody, kicking and screaming, I'll do it in a heartbeat. Do you understand?
Sure.
I'm ordering you as a condition, I'm going to find probable cause on both of your cases, and I'm ordering you not to have any contact with either of the people in this case.
Sure.
There's a protective order that has been issued in the family case. I would get to know it. Don't say anything. You will get the opportunity. Now is not that time. I'm telling you what the expectation is while these cases are open, and what the expectation is for you to be able to live in this free world. Because if you don't abide by these expectations, I'm going to take the free world away from you. You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. You're also not to have contact with either of these people, not to be in possession of any weapons, and abide by the conditions of the protective order. If you violate those conditions of the protective order, the state can file a fourth case, a violation of a protective order. If they do, that is the capital murder of misdemeanors. It's one of the worst cases you can pick up, and you violate those conditions, I can have a hearing to hold you at zero bond. Zero bond, and I'll do it in a heartbeat to protect every person. Do you understand?
Yes, sir. Yes, Your Honor.
Do you have a Texas driver license?
I do, but it's
So you do not have a Texas driver license. I am now ordering you also as a condition of your bond not to drive. You will be signing an affidavit with me today promising you that you're not going to drive. I don't care what's going on in your life. I don't care what you got to do. I don't care where you got to go. You violate this, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car.
an Ubering to and from, so.
Don't. There's nothing you can say to justify. I'm not asking you. I'm telling you what the expectation is.
Yes, Your Honor.
We are now going to reset your case to give you time to hire a lawyer. So for now, I'm going to have you come up here, sign this order, promising us you're not going to drive. I will get you to Victoria, where we will have you sign a reset for you to go get a lawyer. You will meet with Fleischer for your bond conditions, and after that, you'll be free to go.
Sir.
The one in there that has contact.
Got it. Okay. So Rosette, the order in the one that's signed by the magistrate is allowing contact, but I'm going to issue one now so that he cannot have contact. Okay, just so that you know.
Also, I don't see a mower body assault bodily injury case.
Well, it's because it's not a family member case. That's why you can only do one on the family member cases. All right, that way. John D. Hey, bud.
Judge, was that CHA?
Sorry, I'm wrong.
We like Victoria Venable. Oh, thank you.
John D.
Judge.
What's the word?
First on young Mr. Cuellar, Diego Cuellar. He's due back today because he wanted some proof that he's getting his CCD. I spoke to him this morning. he had to get an ID in order for him to get his high
I
school.
think he's supposed to come here with his ID today, wasn't he?
That he showed me a proof that he's applying for it. He hasn't gotten the ID.
Come up.
And he's got proof on his phone that he's been researching the GED program. So he's taken active steps towards the judge. He just doesn't have the ID in order for him to get the transcript. so that
Mr.
he
Bear, you haven't done
officially in the
absolutely.
GED program. right?
I have to wait for the school to mail them the transcript so I can get the ID. They said I need my old school record so they have proof of who I am. But I have my GED login on my phone. I can show you.
To go get an ID, all you have to do is go to DPS and get an ID, right?
If they're under the age, they actually have to have a student verification form from a school.
That's what he's waiting for.
I was there
He's got
yesterday.
the, he's got,
What school is this?
Calhoun High School in Port Lavaca. Calhoun High School in Port Lavaca. I called them yesterday. They're gonna mail it.
The day before court, you call,
That was when I had my appointment for the DPS.
okay? So how long are we gonna wait for you to get the ID to be able to start on your GED?
Well, they said they mailed it already, so probably it's like a couple of days, like 3 days.
So let's set it a week. Okay, all right, I'll see you in a week, sir. All right.
okay, go ahead. I'll-
Judge,
I'll-
was
I'll
that
text you.
Cuellar?
Yeah,
Yes, that was quick.
okay, John D,
Did you
who's
get the
next?
results for his stress test?
Well, you sent,
Second, I'll check.
you sent him to get tested last time, but it's not, it hasn't been 30 days, Judge, because you wanted him to come back to show proof. So,
That's all right, John.
so I think by next time, he told me it's clearing out. So that's good. The next one I have, Judge, is, well, we have to approach on Mr. Yeah, Imamovich, Judge. They're gonna
With an
file
I?
with an IMA.
Oh, you're dismissing it?
Yes, there's,
Yes, Judge. So I think, so we had dismissed the ABI, but I don't think we ever got the MOA dismissed. And so he got picked up on a VPO.
so,
But we don't plan on moving forward with the
Okay, all
VPO.
right, I'll sign it.
got it, Judge.
Thank you,
And then
Judge.
lastly, I have Mr. Johnson, but they are.
So there's the proof. You see that?
Well, hey,
Even if the case gets dismissed, the DPO still lives on.
there you go, Judge. But it's good news, right things being
Yeah,
done.
you're doing it right.
Mr. Johnson, they are seeking some chief discussion in order to get that off your docket
The
today.
case
I'm
is
just
not
waiting.
open.
No, I got you, but I just want to give you an update on it.
Might-
It might be off your docket today. 'cause
She's looking at it.
How much you want?
1 week. 1 week. No, make sure he's getting his ID, and then we're gonna start working on the GED.
So to get clear, you wanted him drug tested on the second today for the results, and they're positive. Are we gonna retest anytime? So I can.
When was the first drug test?
The first one was on November 8th, and then the second one, we did it on December 2nd.
Both of those were positive.
Both of those are positive. I did check the levels, and it did dissipate quite a bit.
Okay, so where are we at now? You drug tested him today?
No, on the 2nd of December.
I know, but have we drug tested him lately? Let's send him right now
I think he went, he just went.
to do it.
Okay,
Great.
I'll create an appointment over there. Will you call him and tell him?
I will definitely try to.
Okay.
Get it done.
Amy, Mr. Preston,
Who do you want to take?
are you not together?
We were just doing a waiver. We just need to get something signed. Just done.
Okay,
Hi, Judge. Judge, I'm approaching you on a case that's on your docket tomorrow.
Okay.
Can I give you the case number, Judge?
or is it a, you want to do PC today?
No, I need a favor from you, Judge.
The cost number.
It's 2542069.
It's a DWI?
Yes, sir.
Okay.
Okay, here's the deal with this, Judge. This defendant has hired me to do his DWI and deportation case. He made bond here in your court and was transferred to immigration court. I have I'm putting together a bond packet to apply for a bond over there.
Okay.
The problem for me is if you revoke the bond here, then he's gonna like come back here, it's gonna turn into a mess. So I need to
I
reset.
don't care. I'm gonna revoke it.
What?
I'm gonna revoke it anyways. I'm kidding, I'm kidding, I'm kidding.
Okay.
I'll let you, yeah, of course.
Okay,
Show me proof he's in ICE
I got it.
custody, and then we'll set him off. Just, you need to keep me in the loop.
yeah, I'll bring him here the very.
Yeah.
That he, and that's the hearing, actually, here's the result showing he's in ICE custody. So, That's the
I
master
guess-
hearing, but that's, I may get a bond hearing before then.
Okay,
So as soon as he gets out, I'll bring him here.
I trust you. Do you want to set it for the day after the 15th? You want to set it for the 15th then, for now, January?
Yeah, that's fine. I should hopefully have a bond hearing before that. I'll let you know, but if, like I said, if he gets out sooner, I'll bring him here.
Morgan, do you want to take notes? Did you hear that? Can I give you the cause number?
No, I have the cause number, Judge.
He's in ICE custody. I'm not going to revoke it just because he's in ICE custody. He's got a bond hearing set
We don't
for,
have a bond hearing set yet. He's got a master hearing. And once I file a motion to set bond, they'll have a bond hearing. I haven't,
So what is it?
I have to get a lot of stuff. I need like tax returns.
so the master hearing is that a hearing to whether to deport him or not, or?
That starts that process, but if you get a bond hearing, if you get out on bond, what happens is your case gets transferred to a non-detained docket.
Okay.
So it will not, then that would cancel out that hearing. So I anticipate getting a hearing prior to that date, and hopefully he'll make.
So-
If he does, I'll bring him.
Then whatever day you want to pull,
Okay,
I don't care.
all right,
Just let Victoria know,
I'll let her
and
know.
we'll set it for that day.
okay,
And once he gets out, if he gets out, next business day, he's got to come here. and
I'll
then
have him here.
You got, it?
I'm good.
We're cool, okay.
Thank you. Thank you.
Okay.
Judge, would you mind signing the Nolly for Mamovic? I'm just have an intake prosecutor asking me to send it to him for the PC, Judge. Thank you.
Yeah, I think I just gave
Don't
her
have
the
it.
case number, so she's working on it.
Okay,
I don't have it.
She's
Okay.
pulling it out.
okay, sorry. You just sent me an email.
For who? I guess, right, I'm gonna withdraw the motion,
Right,
because he's gonna be getting arrested. Yeah,
right, that's correct.
yeah.
And then the intake prosecutor is going to send your signed Nolly on the BPO to the magistrate there so that they'll find no. Basically, it's just-
Who's he looking for? Hi.
If you recall, you had emailed me about Tristan Johnson, and I was not gonna be here tomorrow. He is here.
1 second.
It's on tomorrow's docket.
I'll probably get it. I will. You want me like, if he gets out? Yeah, I will.
Okay.
So he is set for a BVR. Johnson? You need a cause number 2538599.
Tristan Johnson, come up.
This way.
I'm not happy with you, Mr. Johnson. You're on bond in this case, and now you've picked up a felony case. The only thing I asked you to do behave yourself. Don't pick up any new cases. And now, Morgan, what has Mr. Johnson picked up?
Unauthorized possession of a catalytic converter.
Wow, what happened? Please.
So officers were dispatched to an apartment complex. The security guard in the apartment complex observed the defendant. Observed in plain view in the defendant's vehicle 3 catalytic converters that were freshly and jaggedly cut. The defendants were not mechanics. There's 2 defendants in this case. Defendant 1 was under a vehicle cutting the converter. When he saw security, he attempted to escape by jumping into a vehicle where defendant 2 was in the driver's seat. Security stopped them from leaving.
So where was Mr. Johnson?
I'm just trying to figure out if he was the number 1 or number 2 defendant, Judge. 1 second.
Right, where was he? Was he in the car? How do we know if it's him? If, I mean, I don't want to try the case, right? But I don't want to.
Sorry, Judge, in the DIMS, they just identified the defendant 1 and 2. Let me just pull up the offense report really quickly. Okay, so Mr. Johnson was under the car. He was the defendant that was under the car, and then there was another defendant in a waiting
So
vehicle.
was he in the act of taking another one?
Yes, he was in the act of trying to steal a catalytic converter when the security guard caught him.
I am now going to revoke your bond on your first case. I asked you not to get in trouble. You've now picked up a felony case. Is there anything that you would like to add?
Your Honor, I would ask that the court set a bond and obviously.
I mean, that's.
I understand. Yeah.
That's, each one of those is like $5,000-6,000 and someone has to. Life's hard enough as it is, man. You know, really. It goes with you. Okay, 5,001. Or 5,002, no, yeah.
5,002?
Yes, yeah. Okay, correct. Okay, thank you, sorry. Okay, count, you ready? Hey, yeah, hey, man.
I have Aaron Reyes. Hey, Doc. He picked up, I think, picked up 1 felony for sure upstairs.
Is he in there?
I haven't looked, Judge.
Reyes?
Yeah.
Let me see, hold on.
And it's page 41, Your Honor.
Thanks, I'm trying to look at it. Yeah, okay, so that's right, Eddie, he's on bond for UUMB. We got him on, picks up a gun case, and he picks up a delivery case at the same time. Now he's picked up a possession of an unlawful use of a criminal instrument. I mean, I can't, you know, he's on bond. I'll leave it at, I'll do it at 5,001,
I understand.
but
They're trying to no bond him, so we have a bond hearing upstairs, January the 23rd.
okay, just keep us in the loop. And
Yes,
then
sir.
It's at 5,000 now. I'll revoke it, set it at 5,001, and then you just keep us in the loop.
Thank you, Judge.
Okay, thanks, man.
What's the last name, Reyes?
That was Reyes, yeah. I think he was on I want to say a PR. Was he on a PR mode? No, it was a shirt.
Hi, Judge Venable.
Thank you for waiting.
Of course. Your Honor, I have Mr. Ernesto Gutierrez on the docket this morning.
Okay.
The state, well, whenever you're ready.
Ready.
The state has made an offer, Judge, of 270 days Harris County Jail. We are coming to you today, Judge, for, as without anything, to see if you have a recommendation on this case.
Do we have a dead body in the case?
Judge, I'm gonna grab my chief for this.
Kelsey, can you please?
Peach, please.
Hey, Judge, Brian.
Let me put it to where there's an announcement. Sorry.
Council for reset.
Okay. Hi, Ms. Ziegler. Good morning.
Hello, good morning.
So it's making a firearm accessible to a child. Did someone pass away as a result?
So this one was the defendant, is the father of the children. There were 3 children playing. And then the gun or the weapon was found on the bed, and one of the children was trying to get rid of the gun and then ended up shooting and killing his 10-year-old brother, shooting in the side of his head. And I spoke with Caroline on this, but I was more comfortable deferring to you without an agreed rec on what you thought was appropriate here.
I don't know.
I looked at the mitigation packet, but
What'd you think?
for some reason, the case is 2 years old and it was only a 7-page packet. I felt that his statement wasn't really, taking as much responsibility overtly for this. And then it was images of their family. I understand all of that, but with 2 years going on, I don't know why this wasn't resolved with the other chiefs or what's going on, but I just wanted to see a little more with it.
Mr. Gutierrez, come up. Come up. Oh, he doesn't speak English. Got it.
Morning, Judge.
Hi, Luis, how are you? So are you okay with going without an agreed rec, Ms. Ziegler?
Sorry?
Are you okay with going without an agreed rec? Where was the weapon initially? Do you know?
It was found on the bed.
Just the gun is laying, a gun is, just- well, I mean, do we know where it was initially before it was used? I guess that's my question.
There were several guns in the house. If you, one moment, let me pull up DOR, but this one that was involved in the accident was found on the bed. 1 second. The mother, the complainant, or sorry, next of kin advised that she was told that one of her children was trying to make the bed and in the process moved the firearm and it was discharged. And the child did not know that the gun was loaded.
The worst, that's a worst nightmare.
I know.
Just, it's awful. I don't know. I don't. I think that there has to be some punishment, right?
Your Honor, we're happy to speak to him and have him redo his mitigation packet.
But the thing is that he's had the chance to do it. You know what you're supposed to do. And if you can't own up to it at that time, then, I mean, that's truly what you mean at that time. Right? So I'd like to see it, if you don't mind, his letter to see how he feels. Is he truly remorseful? You know, because, you know, on one end, I would think that the fact that your own child is dead because of you, is that punishment enough? Right?
That's where I was at too, Your Honor, which I was conflicting on.
If you can't even take responsibility for it, I mean,
And
You
the
know,
next of kin, the mother, the fire chief did speak with her in person. We followed up with her over the phone. And she has expressed they've all been to therapy, obviously, and she said to leave it up to us.
Are they still together? Is the family still together?
Yes.
So let's do this. Let's get the plea done. I'd like to get it done today. It's 200 days old. Do it. There's gonna be some. Okay? Not as much, but there's gonna be some. And then, but then I'd like to see his letter first, though, if you don't mind, okay? And then,
It's in Spanish, so.
it's okay, I can read Spanish. And then, do you want to go ahead and write it up and do it today? Or do you want, tell me how you want to do this.
I would, whatever the recommendation is, I would like some time to talk to him about it.
Okay.
And if he would like to take it today, then we can take it today, but if not, then I would ask for something.
No, if he doesn't take it, we're gonna set it. It's 200 days old. It's time. So I guess let me take a look at the letter. Let me read it and then I'll get back to you. And then give me 15 minutes. Let me just talk to them and then, okay?
Absolutely.
Okay,
Thank you so much.
sure.
I'll print it right now.
Thanks. Hi, Will.
Morning, Judge. Okay, I have Mr. Paez on your docket, P-A-E-Z. How old are the kids?
10.
40?
10 was the deceased, right? Okay, so it was a 10-year-old that shot the 8-year-old?
Yes.
I mean, is it punishment enough that you know in your conscience that because of you, you have to assume kids are so crafty. Kids can find anything, man, We had a firearm case once like this where it was in a bookshelf and the bookshelf was 15 feet high. But the kid, boom. Okay, anyways.
Okay, well, this is not much better. Paez.
Is he in custody?
He's in custody, and let me talk first before we. P-A-E-Z. I think it's hyphenated, Paez Gonzalez. First name.
Yeah, I see it.
He was out on bond in this court for an indecency. He's got a crazy history of indecency. Picks up some more charges, another misdemeanor indecency, which was no PC, felony indecency, because there's a child involved, and a trespass. I talked to my client. He's got severe mental disability issues. I filled out and trying to get him a TRES scheduled. I think he's got a $75,000 bond on the felonies, homeless, no way he's getting out. So I think the felony is going to probably be the controlling case here.
What would you like? What do you want?
Victoria told me to approach on it. I just want to reset to run with the felony. It's because he was on bond and picked up new cases in this court. That's what it is. But the new case.
Oh, right.
The only new case in this court is
my question is this. That's a decency cases, right? It's exposure convictions.
Yes, I think so, Judge, because I was looking at that this morning, actually. I think he might only have one conviction and then the other was dismissed.
Okay. So now.
There's a pending felony case for the child was involved.
Right. But
so that's gonna.
Okay, either way, whether he pleads, there's registration required, chapter 62 registration,
I'd like to just run this with the felony. I mean, the felony's not set until February.
Well, I mean, we got him on a $500 bond he's unable to make. So even if we revoke the other one, right, it's neither here nor there.
Nothing I don't think needs to be done.
So you're set in the felony on the. We'll carry it, I guess. I don't want to set it out 2 months because it's too long. Let's do 30, come back. If nothing's happened, we'll do another 30 until we get there and then we'll.
Yes, sir.
Okay. Thanks, Will. Hi.
I've got Mr. Bethley, of which I need Amy.
Here, I need to give you something.
Okay.
And I'm okay with it. I'm okay with
With what?
this.
Oh, I'll read it.
It's Mr. Wiggins wants a bond reduction.
Okay. I'll read it.
Looks like he's trying to make bond. Looks like, I'm assuming he's trying to make bond, you know?
Yeah.
And I don't remember if he's still at no bond on any of them. But
I'll take a peek,
read
Judge.
it when you're done, let me know, and then let's work something out.
Will do, Judge.
Please.
For today with Amy, I have Mr. Bethley on the fugitive docket. His 14 days has expired. This is our check-in date. Louisiana has not come and picked him up and.
What? Louisiana?
I called them yesterday. They said that they're not going to pick him up. They just.
So are you gonna dismiss it?
Well, they have this, Day wants the sheriff's office to receive a teletype to release him first, which is why Day has not dismissed it.
Okay.
I'm gonna go
Is
back.
that gonna happen today?
I'm gonna go back and call them.
Okay, yeah, get a move on. If not, then I'm just gonna give him a PR bond, you know?
Now, so that was my conversation of.
If I can, what kind of case is it? If I can,
Simple criminal damage to property.
yeah, I mean, if it's something that carries life, I can't do it.
Yeah.
Right, okay, done. We'll work it.
Do we want to roll him for tomorrow so we can confirm?
No,
or-
no, it's 10:40.
Okay,
Let's,
so
can you,
reapproach before doc closes, and if it's not dismissed, then PR. Okay, thank you, Judge. And I'll look into this.
okay, Ms. Shealy.
I'm approaching on Demarcus Jones. I was just appointed.
Okay, yeah,
So it looks like he was on bond and then was charged with a new case, false ID case.
yeah, so he's on bond for a felony theft. Picks up a case with us, now he's picked up a third case. So I will leave the new case alone, but I'm gonna revoke the second case.
Okay.
And then I'll leave it at 5,001.
Okay, my argument would be, I think they detained him because they smelled marijuana, but they never found any marijuana. And then he.
Well, that's not what he's charged with, though.
I understand.
He's charged with failure to ID, and I mean, I don't know why you would.
Why you would say something, if you're not committing a crime, why would you say?
I mean, really, it's so, now, if he's unable to make bond after some time, come back and we can talk.
Okay, about reduction. Okay.
Sure, or you know what, I'm not adverse to giving another chance, right?
I mean, to
But
me,
he's got to know that we mean business, right?
I
I'm
mean,
not gonna like just,
at least he didn't have marijuana. He just allegedly said the wrong, gave a wrong name.
I'm with you. So give it a couple days.
Okay,
If he's unable to come back, we can talk.
okay. And so that it'll be, did you say 5,000 and?
Yeah.
Two on
No, 5,003.
on the POM.
Uh-huh. Yeah.
Okay,
And, give it like Monday. and We
okay,
can talk.
okay. I will.
Gotcha. It's up to you.
All right. Good morning, Mr. Daly. What would you like?
So Judge, two things. I've talked to Madam Prosecutor on this case, Judge, and I'm approaching on two things. One, bond reinstatement and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler? Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we looked at, I'm sorry, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't
And
disagree.
It's classic sovereign case where got the license plate, think that what is the traveling by right is what I think how they term it. You know,
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
but he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is for now, this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
you know, they ask you to come out of the car one time. Yeah, you know, it's really, that's, so, I mean, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond is set at 2501, and you've continually failed to appear. So, you know, the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that? How do we deal with that, Timberland?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police. So I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up, what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration, number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case. What you know about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you. I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
Not right now.
You're not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberlane,
Thank you,
I'll
Your
reinstate the bond.
Thank you, Your Honor.
And
I'll talk to her. We were going to try to talk to Chief, but it's pretty busy
I
today.
think the case is only 3 months old,
Yes,
so
sir.
you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL or whatnot, or you get arrested for something else, all bets off. We good? I'm not asking for much, man. Really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young Black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over. Okay? All right. Good luck, guys.
Thank you, Your Honor.
Yes, ma'am.
Thank you, Judge. Go ahead. Thank you. Thank you. You want to show this to Chief?
Yeah, I just sent her.
Thank you.
Of course.
Thank you, Judge. Soko.
Good morning, Judge. Good morning, Judge. I'm here on Mr. Bazile. It's an interesting case, really. On Mr. Bazile, Lawrence Bazile. It looks like he's being booked on a case that he's already served time for.
We're looking into that, Judge. I think Alex brought that to my attention yesterday, because there's two VPOs that were like 1 day apart. That the offense date is listed as 1 day apart, and so we are looking into it to see if it was a mistake.
Give me 1 second. I gotta get this out.
Okay.
Okay.
Okay, I'm sorry. Sorry.
Oh, it's okay. So Alex brought this to my attention yesterday because I believe he spoke to the complainant in the case who's listed in the protective order. And we're just trying to discern whether this was all the same transaction or if it was actually two separate dates.
You're talking about.
Oh, Brazil or Bazile, Bazile.
Yeah, Bazile. Yeah, Lawrence Bazile. And he was booked on I believe the 30th and got out on the 12th. So even if this happened on the 29th or the 30th, I think he was arrested already on that 30th.
What do you want, Ms. Oko?
He's here on a VPO that happened on the day he was arrested for a VPO that he did a conviction on. So this VPO should be dismissed.
Well, it looks like there was the first VPO that he took a conviction on, which occurred on the 30th, but the second VPO, while it was filed after, happened on the 29th, the same day as the Burkhab. And we're looking into.
Hold on. So he has a VPO here that was disposed of on September 12th. Is this the one you're talking about, right?
Well, there's two, Judge. So that one occurred on the 30th, and then it was a late filing of a one that had occurred on the 29th.
And it looks like they're out of the same, I mean, I looked at both of the ORs and they looked to be at the same dates. One, I think one on the 29th, one on the 30th.
I mean, 29th, 30th of what?
August.
August.
You gotta look at the charging instrument, Chisholm.
I looked at the charging instrument. One is this one's on the 29th. The one that he's on for today it has a date of the 29th of August.
It's on the 30th though. The charging instrument says the 30th.
Well, because one charging instrument alleges VPO on the 29th, the other alleges VPO on the 30th. And I believe he was arrested and convicted of
On the
one
30th.
Correct, but there was still one prior that was at the same transaction as the Berg have.
Yes.
Which is the 29th.
So are you taking any issues with these?
Judge, I think that Alex completed the RIP for the complainant at the BPO yesterday. We are just trying to figure out, because from what I understand, the facts state that on the 30th, he was on the sidewalk, but he was within 200 feet, which is still a violation. But then on the 29th, he actually entered the house, which is why he was also charged with Berg have. So from what I understand, it's two separate incidents, but I understand that there could be a mistake, and we're looking into it right now, Judge.
Okay.
Can we like look further into it? I mean, I need time to look into it as well to see. I don't, if it's a mistake, then I certainly don't want to hold him, right? But we got to make sure. I mean, let me do this. Let me talk with Nathan real quick, and then I'll do a deeper dive into it. Can you just give me a bit?
Yes, Judge. Do you want us to reset it to tomorrow?
I mean, they've done PC, right? Because I'm assuming so because he's in custody, but I don't know anything about either of the cases, so.
Right. I mean, the magistrate found PC on the cases, but you haven't.
Right. Okay. Are you busy, Ms. Oko, or no?
No, Judge, I'm not.
Give me 1 second. What do you guys need?
Sure.
We're gonna politely have a conversation with you in the back if we can.
Okay, come on. Does it have to be polite?
Well,
I'm always polite.
Yeah.
Except, you know, but that's not.
I'm giving a lecture for 5 nights, except for
Specifically.
I've always been the qualifier.
I'm gonna grant.
Yes, Judge. Do you need me to find class numbers for you? Or you got it? I'll get you the letter.
Please. Hi, Dustin.
Hi, Judge.
Hey, sorry.
That's the swing by. My approach, or
No, I'm cutting you off.
come on, man.
At the knees.
I need these bees.
Just initial it. Where is it?
Here, I'll give you the letter back and we'll have to get scanned.
Is it that?
Oh, this one, the
Just
withdrawn?
initial it or where it says withdraw?
Remind me, I got to sponsor the tent again this year. I didn't do it last year because my wife was pregnant.
I'll get you some lunch. I ain't got my form yet, but when I get, I'll just make a copy and send it to you.
Okay, Dustin.
Good morning, Judge.
I don't get
So-
that.
Ben heard with me last week. I was in Cancun. I guess there's a TVR for positive alcohol.
He's out now. Don't want any more issues. Just. Don't want any more issues. I'm not asking much. Just do what you need to do. Really, you know?
Judge, pretrial, I talked to pretrial, they said they're gonna, they listed it about the THC or I don't know how you wanted to.
God, it's only 70 days old too.
So Judge,
All this trauma and it's only been 70 days.
is that it?
Yeah.
The lab is back. There's no alcohol, which we expected that already. We're still waiting for drug analysis, but I think as soon as that's back and the state's ready, we just either just try it or, just try it. Let's get done.
Is that where this is headed?
Well, I looked at I've evaled it and I don't think it's the DWI. I don't think it's intoxicated when I looked at the eval, but but the state can't do a full eval until they have their labs for the blood. And
Tell me what you
I
think.
expect that.
I mean, I'm going to tell you now, this has so much drama, Ms. Saba, that I'm like ready to pony it up with Dustin as well. You know, I don't want to sit and wait another 6 months. And
Judge, we don't,
Oh, that's wonderful. Hi, you look great. You know,
what were you?
It's gonna be a
Jones?
an alleged drug case.
Oh, yeah, we
Is
don't, we
there a
just don't
DRE
have the
done?
toxicology report
DRE?
yet, Judge.
I can hear, I'm sorry.
DRE, shh. Was there a DRE?
Theory? Yeah.
We just don't have the toxicology report yet, Judge, so, and the case is only 2 months old.
I know, no, well, yeah, a little bit over, but yeah.
A little bit over.
How long do you think it'll take?
I think it should take 1 more month, because sometimes I've seen them take up to 4, but maybe we can give it like 1 more setting before we.
Yeah, okay, we'll sit you off 30 days.
Still have them come in to do drug testing.
Yeah, just don't use, you know? All right, so we'll continue supervision now, Felicia.
Judge, just to clarify, so you are permitting the usage of THC?
No, I don't,
So that's like the dilemma here.
I know.
So I don't, because we're just gonna continue about.
Yeah, I mean, how do we deal with this? I don't,
Let's get the labs back and feed out and try.
I'm not down with you continue to use marijuana. I'm not down with it, Mr. Jones. I don't want you to use. There has to be an alternate method to dealing with issues.
See a doctor and all kinds of stuff still though.
Yes, yes, that's what you're supposed to do. You're not supposed to self-medicate.
He's not self-medicating. He's got a prescription for marijuana. And I know we've gone down this road already. So he's not self-medicating. He's under doctor's orders.
He has a second DWI that's open. I don't want you using, Mr. Jones. Just the plain and simple of it. I mean, don't. Do you understand? Don't use and get ready, please. It's way too much drama. I'm ready to put this baby to bed one way or the other.
We'll reach out to the lab and do an
Please.
eval.
All right, I'm gonna do 30 days. I'm gonna continue it now. Don't use. You've got 40 days. Do you understand? Yes or no?
Sir.
Okay, get ready. All right, Dustin.
I just hate remembering the exact same suit and tie. Like the last time I had this
Happy
conversation.
that you're here. I hope you had a great vacation. You know,
It is nice. I did a no work, like 0 work vacation. I didn't take my laptop.
that's what it's supposed to do. We love you, Dustin. Okay, Nathan, you ready?
You're on at
It's
28,
your,
right?
hey,
Yeah, so I
I don't know
mentioned
why I
it,
went to Nathan. I'm
Well, so-
sorry.
It's okay.
I'm on it too, but she is, I guess, lead counsel.
He sent me a letter,
Okay,
wants me to reduce the bond,
okay,
and I will.
okay.
To what?
So Miss Edie and I were having, wait, you talk, I'm not.
Okay, so I thought we had already reduced that to 75.
Not that I
Okay.
remember. But I'm okay with that.
Okay,
How about 25?
he's got so many, Judge, that,
He's just, I'm okay with 75.
okay,
Okay, definitely 75.
So that's 75 on the one that's 250. There's another one in this court that's 50.
I'll leave it at that.
Okay.
Okay,
What do we need to do?
nothing.
Excellent.
Take care before you.
okay, thank you.
You can't tell me what to do.
I keep telling that to my mom. On my fugitive case, I believe we're still waiting, so I'll circle back again.
Okay,
Thank you, Judge.
so what was the cause number again?
250545146.
That's the one on the paper. I don't know if that's the right one.
So that one's not gonna be reduced?
He's got 6 cases.
I
2
don't
in
know.
this court at least.
Yeah, it's like 1 bazillion versus 2 bazillion.
Yeah.
That's the right one.
Thank you, Judge.
And I'll do a bail order now,
Perfect, thank you.
saying that's reduced.
Good morning, Judge. May I approach?
Sure.
I have Miguel Mendoza on docket today. We emailed yesterday about this, how he's checking into safety. I spoke with him this morning and he was checking in.
Is that the facility the staff were asking if we needed him to come before.
No. We just want to make sure that he's checking in. Okay, he has checked in, Hugh,
Yes.
which is great news. So next, begs the next question. How long?
I'm gonna say 6 months, but let me verify with staff.
Do we really want to set it out 6 months? I guess let's do this. We'll set it out 3 to make sure he's still doing well. Is this the type of facility that you can up and leave at any time? Okay, great. So then I'm okay with doing the 6 months then. So Hugh, it's not a facility where you can just up and take off like some of the other ones.
Yes,
So
yeah.
we'll set it off 6 months and, I guess we'll come back at that point, or maybe like 5.5 months, and then just to make sure that everything's still on the up and up, and then we'll figure it out from there.
Okay.
Okay?
That's great.
Okay, man.
All right. Thank you, Judge.
Thanks. Take care.
You too. Bye.
Bye. All right, come on up.
How are you doing?
All right.
Good, good. We have 2 on your docket this morning.
Okay.
The first one is Mr. Jordan Stanford.
In custody.
Yes, sir.
That's okay. Okay.
So Judge, kind of, I guess, a scenario. This case is old.
Yeah.
He has pretty serious pending felonies where the offer is 20 years that we're still trying to work through. Yeah. He's been in custody, I think, over 200 days at this point. He has more than enough time for a time served. State has offered it. You need to talk to him about it. But the issue is that if he does take that, the felony court is going to consider that as him burning his time that he's kind of saved up. Spoke to the state about it. They're going to take a look at it again to see if they can possibly just drop it and the felony can use it in punishment or further eval it for something.
They're not set till February 7th.
And
What's going on up there on that day?
So Judge, the state does have an
told you 180 days county that was put in by felony. I did ask defense if we could, because I understand that now we're in a position where because the misdemeanor is so old that I understand you probably want to set it on the trial docket. I would just ask that we get an eval setting. We haven't had one yet, just so I can take a look at it. It can be a brief one, Judge.
And it's set for disposition in felony court.
I want to set it to
February, and that was the issue. It's so far
It's
out.
just too long for an eval. So
Yeah, I understand.
do a couple weeks, okay, and then just, I guess, let us know.
Yeah.
For sure.
In the meantime, we'll check in with felony before that.
Okay, of course.
And then the other one, Judge, is Mr. Jashawn Harris.
On bond or in custody?
He's on bond.
Okay. All right.
DWI case, we subbed in on this case in October, Judge. I have reviewed the evidence, spoken with the state. He does qualify for PTI, does not need to do a mitigation packet. The issue was he had juvenile history. I wasn't sure if they could take that into consideration as actual criminal history. We reached out to Nathan Vito. He said, no packet packet needed. So we're just going to send out the
You're gonna
application.
go that route? Okay, so you're at 130 now. We can give you a normal setting next time. Have it turned in, have him come, and then we'll send him for a TRAS next time. Yeah?
All right,
Okay.
that's everything that I have.
Thanks.
Thank you. Have a good one.
You too. All right, you ready? Hey, good job, Josh.
So we have an update for you, Ms. Brown. So I believe Morgan spoke with or Alex spoke with the complainant yesterday. The supervisors are saying we can keep them separate. The complainant said, well, I don't know, I may go, around her. And so,
Yeah, it's kind of a complicated situation because the complainant is an employee of the group home, but we spoke to Paige's caseworker yesterday, so I'm not sure about the authority level there, but the complainant stated that she doesn't want contact with the defendant and does not want her to return to the group home.
No.
The authority of the, I don't, so.
the case manager said it shouldn't be any issue keeping them
Right.
apart, and she said that'd be fine, but.
Are you, I mean.
Because the case manager told me that.
What else do we do? I mean, there's nowhere else physically that she could go.
Right.
I mean, this is literally, otherwise it's the street.
It looks like, you know, like I said, the caseworker said that the complainant can be assigned to one building because I think it's comprised of 4 separate buildings. So the caseworker can be, the complainant can be assigned to one and Paige can go to another. But it's just like the complainant versus the caseworker. I don't, you know, Judge, so I don't understand how
Well,
this is set up.
hopefully, I guess I would say just caseworker said that they can separate them. Let's make sure that that happens. And hopefully the CW doesn't add fuel to it, you know? I say I'm still okay with it if you are, Morgan. Yeah?
I'm okay with
All right,
that.
let's do it. Yeah, we'll keep it. Okay, thanks. Hi.
Alice on the docket today, our DWI MRP. Custody because he didn't take the drug test. He said he couldn't. So he's back there now, and I wanted to know if you're willing to send us a and he does also have a
We can't send him to SADC then. If he's got an open case, we can, right?
On the PTI, it looks like they did this contract for him to go to residential.
That's correct. It was residential.
So yeah, I will, SADC is great. Yes, yeah.
So can, wait.
Let's do the SADC. Yeah, SADC. Yeah. I think that was always the idea, always. Yeah, let's do it, for sure.
I'll try not to solve stuff. I see the headline, so. You know what's in
And for what it's worth with the CPS stuff, I filed those proper motions and let the CPS contact know that we were doing that, and they didn't get back with me, so I just shared those.
Okay, thank you. Yeah, no, it's up to you, just in case. Actually, it's for some reason, I don't know why it was marked. Yes.
He doesn't talk about the event at all,
I was
doesn't.
concerned, Ron.
So, you know, typically when they do these types of packets, they usually mention what happened, some kind of, you know, acceptance, if they're going to apply for the diversion, right? And acceptance of responsibility is always one of the things in diversion, right, in the agreements?
Right, yes,
Isn't that
sir.
something that you always, in the DWI, do they also have to accept responsibility as well?
Yes, sir.
Just for example, because I don't know.
Right, yes, sir, they do.
So he doesn't talk about this, doesn't do anything.
Your Honor, if I may, put together that mitigation packet and sent to them. I don't know that I was specifically overseeing it. I am with the firm
I might not be the attorney of record, however, I do know that the worst thing that could possibly happen to him has happened to you. And if we could, if the state would agree to write.
I think what I would like is I want to redo. I want more. I want to know, how has this affected you? What have you done since that time? Have you done anything? You know, and this is just said, hey, man, I was born elsewhere. I came here and I try to follow the law and I try to teach my kids. That's all this literally says. So please, let's set it for a week because it's as old as it is. Let him know we need more. I want to know what happened, specifically what happened. How did it happen? How has it affected you? And then what have you done since then? Right? Those things. And then let's come back in a week and then we can, you know, redo it. I don't know yet as far as, you know, but to me, being proactive goes a long way. I know that losing a child is a lot because I couldn't imagine, right? But show me.
Your Honor, I think that there's a way
If he doesn't accept, then we're going to let him know. If he does not accept responsibility, then we go to trial. Because one of the things when you plead guilty is you have to accept responsibility. It's just one of the core things, right? So you either are guilty or you're not guilty. There's just no in between. Yeah? Okay. Here, I'll give that back to you. And then let's set it a week and then just good luck. Yeah. And you know, for me, I love proactivity. You know, I love when people do stuff on their own initiative to show, hey, I care, but words mean nothing. It's actions that really tell me when a person has been proactive, not just telling me stuff, because everybody tells me things, you know, and you know, when you're a judge, it's like they tell you everything. Okay, yes, of course.
Was it?
Hi.
How are you, Judge?
Been a while.
It has been. I live in Travis County now, so I only get the blessing of coming back to
Nice.
Houston, which they're very different.
Or
The
do they run the
courthouses,
courts
how they do
differently?
everything, yes,
Really?
very much so.
What's the difference?
Clients rarely go to court there, unless it's actually like usually plea papers and stuff. And then the pretrial diversion program is less expensive drastically. It's actually free. They only pay for, they have to pay for their DWI ed and their victim impact panel, but there's no supervisory fees. We check in every 3 months with the judge to make sure people are doing their stuff. And then after you show them 6 months of clean interlock and your certificates, it's dismissed. And then they'll immediately agree to an
Are there
expulsion.
any barriers? Like if it's a high blow?
Yeah.
If you blow like a 3?
I think it's actually 0.2 is when they'll start, is when they stop, or you have to really talk to somebody to try to persuade them. I had a 0.23 with an accident and they wouldn't let them in, but they offered him a deferred on an obstruction. And so it's like, and that's kind of Travis County is just sort of like, okay, well, we can't do that, but let's do this, right?
I can't remember. I can't.
But it's constantly over there.
Back 15 years ago, you get reductions.
You used to get recklessness back when you were with the state.
Obstructions,
but commits a reckless and an obstruction, right? And then I remember one time seeing somebody charged with obstruction. I was like, I don't even know that happened. Like, I thought I was solely there to reduce.
They created it just to be able to reduce.
Yeah, 100%. That's what I always thought it was there for. But so it's just different. I don't know. You know, I've been cases here where it's a 0.02, where we're evaluating a 0.02, right? And I'm just like, well, for what? Like, you know, and there it's 0.23, and here's an obstruction deferred. So.
I'll have a changing of the guard soon, so we'll see how things, you know.
I have one in your court. It's set for next week, but I don't know if they still call it a THA setting. he came by himself. He's hired me since his arraignment. I was just gonna ask the coordinator to move it.
Sure, what do you got?
Just a regular court session.
What was the cause number?
2537563. Early 20s in school, no accident, 0.1 breath.
Yeah, I mean, we'll waive the appearance. So as long as you're on the case, we'll waive the appearance. Sign on now, whatever date you
I'm already
want.
signed on. I was just gonna push it out.
Okay, for sure. Yeah, whatever you want.
Thanks, sir.
Of course. You too.
Saying hi.
Oh.
Judge, hello, goodbye.
How are you, Mr. Morgan?
Judge, I want you to know I miss you every day.
It's, we don't see you enough. And it's a shame.
I watch you on YouTube though, and I go,
Great to see you, friend.
Good to see you.
Have good holidays, because I'll see you in what, 6 months?
I'll be back down here.
Sure. You ain't has a lot, Craig. Good morning, Mr. Colegio. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 30 days in jail, credit for the 12 days that you've done. You need to understand that this is going to go on your record. It's going to be there for the rest of your life. What happens next time?
It won't be a next time, sir.
If I had one strand of hair every time someone told me that right there, I would look like you with hair. Really. If I had one strand. You need to understand that both of these are going to go on your record. They'll be there forever. Even if you have a sip of alcohol, if you get pulled over, an officer's going to see DWI, 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 they're going to probably take you right in. From now on, you're facing a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
So I wouldn't get in the car, even if you've had a sip of alcohol, because if you thought this was bad, wait till you get to felony court. You're giving up the right to a trial, right to compel witnesses. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it goes on your record. You can never take it off. You understand?
Yes, sir.
You still want to do this?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
It's alleged that you had an open container. Is that true or untrue? Did you have an open container of alcohol in the car?
Yeah.
I did discuss that.
I'm going to abandon the second enhancement, but that's an enhancement that makes it a minimum of 5 days in jail to the case, which you've already satisfied it, obviously.
Okay.
But it's still an enhancement that they have on there. They actually have 2 enhancements. Your second enhancement is one that you had. Actually, there's 3 enhancements, actually. So it's also alleged here that you had a prior DWI in County Court 5 in Montgomery County. Is that true or untrue? It's also alleged here that you had a 0.15 or above. Is that true?
I would, due to the actual results, I would ask them to abandon that one.
Okay, I'll abandon that one. I got to look to see because that one might make it 90 days though.
The NCC code has to change. Because it's a DWI second with a 0.15.
It's a second.
With a 15.
Okay,
So we need to, so
because it is a 0.14 and a 0.15, so I would.
do you know what the new NCIC code
It
is?
will be just a DWI second, right?
Yeah. I don't do you guys have the NCIC code for just a DWI second?
Yeah, I think it should be the 14.
I don't know. I want you to understand that there's another big thing about this, Mr. Colegio, that DWIs are big business in Harris County. You know, this right here, there is a $6,000 surcharge that goes on you because this is a second offense. plus court costs of around $500. So because you're in custody now, I'm gonna end up waiving it because you're in custody now, but the more DWIs you pick up, the worse life gets. And it's so easy. All you have to do is hit one button on your phone, $40, and Uber will take you wherever you want to go, man. Don't get into a car again if you've had alcohol, because it's not gonna end up well. Did you find a chance?
Yeah, yes, Judge. I think the paperwork may have to be refiled. I'm not entirely sure. But she's gonna work on it.
Are you okay with abandoning the 15 enhancement?
Last name again?
Colegio, COLL.
AGL.
So then what we'll do. And what's the logic behind that?
Well, one of my fear was that it would make the minimum higher, but the, don't worry about it.
Pretty high, that's why I was. That's what my understanding was. I didn't know that. Mhm. That's scary. That's when I kept it and it's when it was 3. 30 is why.
Okay, so I just say.
You would? Yeah.
Okay. Okay. Yes, sir. Gotcha.
So we can continue with the plea as written.
Okay, so is it true that you had an open container? Did you have an open container?
Yes.
No, you were there.
Yes, yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Okay. Is it true that you had that prior DWI?
Yes, sir.
And it's also true that you had a 0.15 or above?
Yes, sir.
Okay. You know how to act. You know what to do.
Yes, sir.
Just be good in the future. We're not asking much, we want our streets safe. How do you plead to the offense? Guilty or not guilty?
Guilty, sir.
Find you guilty. I will follow the agreements. For cost. So I'm going to waive the DPS fees. I still need that order, please.
Yes, we'll do it.
And then I am going to suspend your license for a year. Do not drive. It's a DWI. It's a second DWI. You're
Okay,
pleading
yes, fine.
guilty.
Thank you, sir. Thank you.
That, look,
Fine, thank you.
you're going to get out of jail.
Can I get an ID, like a regular ID to start working?
Well, of course you can.
Okay, I'm just asking. That was the reason I turned myself in.
Glad that you did.
Thank you.
You're getting out of here probably today. When you get out, don't start driving.
Yes, sir.
Call DPS, They can tell you how to get your license back. And then when you do things the right way, good things happen. If you go out there and you start driving, even though you got to work.
Yes, sir.
Murphy's Law, what can happen will happen. You're probably going to end up getting pulled over and you're going to be right back over here. So do things the right way. Good things happen. All right. Good luck. Thank you. Thank you. Yeah. And then the court costs as well.
Oh, you still. Yes.
Has he signed yet?
Yeah, everything's under.
When you're.
All right, Jacob. Yes.
Bring it with you. Come on around this way, other way.
What's his last name?
Hosa.
Are we doing just a straight?
Straight probation, Judge.
Good morning, Mr. Hinojosa.
Good morning, how you doing?
Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have two cases, actually. You've got the DWI. You also have the unlawful carrying of a weapon. I'm assuming that one is.
No, nulling that, right? Yes.
They're going to dismiss that second case against you. You need to understand that this DWI is going to go on your record. It's going to be there for the rest of your life. What you need to understand is that whenever you get pulled over, an officer is going to see this. If they smell alcohol or they smell dope and they come up and they look that you have a prior DWI, you think things will go well? Probably not. So what I'm telling you is that you now have this DWI that's going on your record. If I were you, I would never get into a car, even if you had a sip of alcohol, because you're taking a humongous risk. Do you understand? After today, you will also have a minimum of 30 days in jail for any other DWIs that you pick up. They can use this to enhance your punishment to a minimum of 30 days in jail. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this or undo this. It will go on your record. It's going to be there forever. Do you understand? Do you still want to do this? How do you plead to the offense of driving while intoxicated? What have you worked out, Mr. Morgan?
That's 1 year, 1 year probation, 30 hours community service, no drugs or alcohol, random urine analysis.
So it's
180 days.
So the agreement is this: for you to successfully complete this probation, it's 180 days in jail. We will probate that for 1 year. As part of the probation, you will do one victim impact panel. What about a DBI education class?
Judge, he has a, judge, that's fine. We can add that in there.
It's not in here now. And I'm going to tell you, Mr. Morgan, that if he doesn't do the education class, they'll probably end up suspending his license. I don't know for sure, but from what I understand, the rule is that if you do the DWI education, the DWI education, it doesn't suspend your license. But did you mean to add?
Added in, Judge.
Oh, it was an oversight.
Accident by my
Okay.
part.
Got it. So you must do a DWI education class, a victim impact panel. No breath test refusal. If you were pulled over in a car and an officer asks you to submit to a breath sample, you must take that sample. Random urinalysis. No drugs, alcohol.
He has 100 hours.
Do you have any children?
You're doing the 30 hours here.
Mr. Morgan, I was gonna.
About the community service. Yeah.
He's on a deferred in felony court as well, Judge, where he has to do community service anyway.
Okay, I was gonna
So-
take that off anyways. I mean, what
We appreciate that,
what I
Joe.
normally do, what I think would be more prudent is if they have children to do like a parenting class in lieu of, but he doesn't have children, so I guess we'll just,
So she's fully, so
um,
he's on his way to become a productive member of society, I imagine. Starting a family at one point, once he's a little more financially stable, will be where he needs to be. Still pretty young though.
you're on felony probation now. You have to have a freaking halo over your head. Because if you don't, you could go to prison for a very long time. Have you been to prison before? If you have any doubts, go online and look at how miserable prison is. It's not a fun place. And I will tell you, there are some parts of prison that the lights don't even go off where people sleep. You can imagine how you have no REM sleep, how much that will play on your psyche and your hormones. It's incredible how bad Texas prisons are. There's no air conditioning. It's freaking awful. If you don't believe me, go look it up. You're on this deferred now, so you got to behave. Do you understand? All right. If you violate this agreement, I'm going to issue a warrant for your arrest. I'm going to put you back in jail. I'm going to bring you right back out, and we're going to talk about whether you violated this agreement. If you violate this agreement, you're looking at up to 180 days in jail. Do you understand? Okay. There's the, what do you do for a living? How much money do you make a month?
Judge, it's contractual, so it's whenever he has business.
There's a surcharge and fines and fees, Mr. Morgan.
And yeah, if we could waive that, as he has a forfeiture pending that is about to make him completely indigent.
Forfeiture.
Yes.
Oh, they took the car?
They took the car and he has been without transportation, and he has been, it's been a struggle to make ends meet. So he's.
What kind of car did you have that they seized?
Okay.
Oh my God. Oh, Lord.
Yeah, no, he was.
Is that like a $90,000 car? How much was that?
Yeah.
You right on the dot right there.
Yep. Yep.
Wow.
Good. And then.
You know, I will tell you, I routinely warn people here about when they end up racing, they do crazy stuff, donuts and this and that. When they pick up a second one, a lot of the times the cars get seized. We see it every now and then when it happens, and here's tried and true. This is a second case, and man, that's a nice, someone's going to get a benefit nicely from that.
Yep.
I hope that you get it, from now on. You don't have to say anything, but I'm just really, actions have consequences, and that's a hell of a, man, I wish I had that kind of car. Here I am with a jalopy. Drive a nicer car than I do.
But with that being said, Judge, if you would be so kind as to waive the surcharges, that would be ideal.
We want you to learn from this, Mr. Hinojosa. This is your first DWI. I will acquiesce to Mr. Morgan, but I'm going to tell you, if you're not smart enough to consider how to get home on a night of drinking, you act like a child, we will treat you like a child. But the way we do it, the way that we spank you is with a ton of jail time, Really, you act like a child, you'll get treated like a child. And I'm going to tell you, I'm waiving nearly $3,500 in fines and fees and surcharges from you now. But I'm going to tell you, a second DWI, it's $6,000 surcharge, not to mention court costs. So you can probably roll out of here with about $7,000 in fines and fees. You pick up a second one. Do you understand? Get a clue. It's not hard. All right, done. I need you to do a waiver for me.
Yeah,
and then I'll grant it for you. And then, all right, good luck.
Thank you, Judge.
Oh,
We agreed to no device.
is that the agreement?
Yes, Judge.
Okay, that's it. I'm going to tell you, we're going to test you. I'm going to test you like crazy. So I know that you're not using. If I find that you use, one of the sanctions that we can do is either guardian interlock or a scram device. Those devices are hundreds of dollars a month. Don't drink, don't use illegal drugs. Do you understand? Okay, man.
Thank you, Judge.
Great to see you like always.
Great to see you, Judge.
Okay, good luck, Mr. Hinojosa.
Thank you, Judge.
You too, man. Take care.
All right, sir, this way for me. You need to get your thumbprint.
I'm live streaming, so
Good to see you, Judge.
great to see you too, Mr. Morgan. Okay.
Thank you very much.
Bye. Thanks, guys. Okay, bye, guys. We have Judge Chow coming in later, who's the second judge in this court. And
Thank you.
let me see. She was the judge from 1987 to 1998. So she's coming in today and we're gonna hang up for.
That's awesome.
Yeah, there's only been 4, so.
That's awesome.
Okay, bye, guys. See you tomorrow.
You can Dunkin', like a rollout.
You leaving too?
Well, yeah. I got my life to live, you know? Oh, yeah.
Let me make sure. Oh, you're not-
Parish.
You're not gonna be here tomorrow? Oh. God.
I didn't mean to scare you, Judge.
Yeah. Okay. All right, guys, I'm gonna log us off.
Well, ladies and gentlemen, that's how it goes. There's the music. That's the end of another docket full of cases. I'm afraid we do have to say goodnight so soon. But, you know, it hasn't really been so soon because it has been 2 hours and 3 minutes full of Fleischer forum action. And ladies and gentlemen, the chat has been amazing tonight. It was fun. Thank you all very much for coming out. You've all made my night a much more pleasurable period of time. These have been some interesting cases. I actually have to admit, I didn't get to see any of this docket today, and when I edited up, I didn't pay attention to what I was really editing. I just edited for time mostly. So everything I saw, I was basically watching with you for the first time, and man, that was a docket. I think we all said the things that we felt we needed to say as they were happening. But a lot of it was kind of shocking. The soft sit was interesting, to say the least. I know that's been making the rounds. Ladies and gentlemen, it is that time of evening. Got to say goodnight to each other. I'm tired. I was yawning and my eyes were watering before the show even started. Now I'm going to turn all this stuff off and I'm going to relax. Ladies and gentlemen, I'm your lone wolf Oozle, and I am your curator for all of these videos here at the Court Gallery. And I am your host for the forum, the Fleischer Forum, and all other live shows like the weekend review, which is coming up in just a couple of days on Saturday at 11 p.m. Or no, 11 a.m. 12 p.m. Eastern Time. Don't pay attention to me. It's too late for me to be talking to people right now. I have no business saying a word. Ladies and gentlemen, we are going to be doing a weekend review. Of course, I'm taking Sunday off because I can't do this every day of the week, for God's sakes. Guys, y'all are great. I love you. We'll see you tomorrow night. We got one more day for the Fleischer Forum. And then we're all getting together for a hodgepodge of some interesting stuff. So I'll see you all there, and may your dreams be in Wi-Fi. Good night, ladies and gentlemen. Love you. Good night, ladies and gentlemen.